In spring 2003, Supreme Court Justices Anthony Kennedy and Sandra Day O'Connor were ready to break ground on gay rights by striking down a ban on intimate relations between same-sex couples. Lawrence v. Texas, issued 20 years ago this month, came before the court at a time when stigma, social norms and violence led many gay Americans to keep their private lives hidden. Just a few years earlier, in 1997, actor and comedian Ellen DeGeneres drew international headlines for being a rare public figure to come out. In 1996, Democratic President Bill Clinton signed the Defense of Marriage Act, prohibiting federal recognition of same-sex marriages. That law, which defined marriage as a union between one man and one woman, would not be struck down until 2013. Getting to the 6-3 ruling in 2003 was no small matter. Kennedy, an appointee of President Ronald Reagan working with justices on the left side of the bench, went through nearly 10 drafts as he explained the Constitution's protection for same-sex relations and inevitably took a major step towards same-sex marriage. The landmark decision set the country on a new path and helped lay the foundation for the 2015 court decision declaring a nationwide right to same-sex marriage. Once private court papers reviewed by CNN and related interviews reveal the internal debate of key justices concerned with LGBTQ rights but moving carefully. Kennedy, writing for the court in the anti-sodomy case, struggled as he outlined the constitutional right at issue and considered using phrases such as the sexual instinct. Kennedy, who held the key vote in this line of cases, was also cognizant of religious interests within the court and beyond. That tension between LGBTQ rights and religion is still evident in controversies at the High Court today. Back in 2003, the one openly gay law clerk, Amy Wildermuth, worked for Justice John Paul Stevens. And he saved suggestions that Wildermuth, now a law professor, made on O'Connor's first draft. The document is among Stevens' files recently opened at the Library of Congress. At the top of Stevens' copy of O'Connor's first draft is the small notation, suggested changes to SOC's opinion from Amy Wildermuth. Throughout the 8-page draft are various edits, mainly concerned with the nuances of phrasing. Are we using the right terms? Are we saying this in a way that could be offensive? If you're not in the culture, you just don't know, Wildermuth said in an interview with CNN about the kinds of questions that came her way. Wildermuth, now teaching at Ohio State Moritz College of Law, emphasized the era when justices were less familiar with LGBTQ interests. I was happy to share my perspective, she said. It was not something I was uncomfortable with. Nothing in the Stevens files indicated why Wildermuth was enlisted. When reached by CNN, she explained, it wasn't unusual for people working on cases to be asked to help the clerks in other chambers, to provide feedback. It also was true that I was the only out gay law clerk at the time. That may also have prompted interest in getting feedback from me and from my co-clerks. Other law clerks serving in other chambers that session similarly remembered Wildermuth as the only openly gay clerk that term. Kennedy conferred with Stevens, Stephen Breyer and other justices on his left. In his first draft striking down the Texas sodomy ban, Kennedy described the right in question to be of such fundamental importance to self-definition that it is protected by the guarantee of liberty in the Due Process Clause. After several drafts, according to Stevens' files, Kennedy decided to avoid the word fundamental. Kennedy also withdrew language that some of his colleagues regarded as awkward or out of place, such as, "The sexual instinct is of endless fascination for the human. Its beauty and power are best respected when the individual has substantial freedom to explore it to attain a better understanding of the concept of self and the place he or she has in a larger universe."